Good morning, Judge Finn. We welcome you to our commission meeting, and we'll ready for your opening remarks.
Okay, thank you. George Davidson just told me as we're walking in, he said, "I've warmed him up really great for you." So good audience. My name's Tim Finn. I'm a district court judge from Ames. I've been doing that for 23 years, and I'm applying for my third time to the Iowa Supreme Court. I was nominated in 2002 or 2001. I went up with Justice Strite and Judge Gamble. Justice Strite was chosen by Governor Vilsack. Art Gamble and I applied again 2 years later. At that time, Justice Wiggins was nominated, and neither Judge Gamble or I were. I didn't apply after that, primarily because I saw what I perceived to be a shift in the what you were looking for members of the Supreme Court, and that the influence or the perception of district court judges was not what you're looking for. When the retention election happened in November, I thought, well, maybe this would be a good time to try again. I want to start by saying two things. One is that last night I got a number of emails and text messages from friends and family. The best one said, "Good luck tomorrow, Tim. Don't worry about the fact that cameras add 10 pounds to your face." Okay? Also, before we get into the meat of it, I do want to talk about one other thing, and that is that 23 years ago, last month, I made my first decision as a district court judge, and that was to hire a court reporter. I hired Pam Hayes, who'd had several years of experience, and it was the best decision that I made. She's still with me. Either she is a glutton for punishment, or she enjoys the work. I raise that for a couple reasons. One is that I want to underscore the importance of court reporters to the trial bench. They are absolutely the backbone of the court system in the rural areas. They serve as the buffer between the judge and the lawyers. They get the lawyers organized. When we go to a rural county, they get the litigants lined up. They type our orders. They take the testimony in court, and they're absolutely essential to the system. The decision that was made under, I guess, exigent circumstances that we could live without them was a mistake, and we've suffered from it. And a lot of the things that people are telling you here is due to that decision to cut back on the court reporters. So, that's the primary reason I raise it, but also to give a shout out to Pam Hayes, who's a wonderful person. She's president of the school board in Webster City, and she's anybody that knows us knows that we're a team and we work together, and that I owe her a lot, and I thank Pam if you're watching this today. These are tough times for the third branch, and I haven't watched all the interviews. In fact, I've hardly watched any, but I know what you're hearing. You're hearing the same thing. I bring to this job a little institutional memory, in that when I graduated from law school, I had the pleasure of working for Justice David Harris for 1 year. And back then, there was no Court of Appeals. There was a 9-member Supreme Court. That court was, in my opinion, staffed by really strong, opinionated, competent, kind, intelligent judges. Judge Harris was one of those people. Judge McCormick was another. Judge Mason from Mason City. Judge Uhlenhop, really stellar, strong personalities and people. In those days, each judge would be given 4 cases a month to write on. And as his clerk, I wrote on the 4 cases that he was going to argue that month, as well as the 4 that were under submission. There was a strong ethic back then that they get their decisions out quickly, and that was in the days when we didn't have all the technology. They had to do it by mail and by phone, and but also at that point, and I don't think geography is a big issue, but at that time, most of the judges were from various places around the state. So I bring that kind of institutional memory of what the Supreme Court can be and what it should be, and it's not a matter of geography. It's a matter of doing your job and doing it well. I was appointed as a district court judge in 1987. I've tried hundreds and hundreds of cases. Before that, after I clerked for Judge Harris, I moved to Ames and we set up our practice there. I understand the ramifications of being a lawyer and also running a business. So I think I understand that very well. I didn't think I had much trial experience when I was appointed to the district court. I'd only tried 28 cases, 28 jury trials. And in retrospect, I find out that's quite a few for 12 years on the bench. So that, you know, you hear these things, you don't know what significance they are. But I came to the bench with a lot of the attributes that I picked up from Judge Harris. A hard worker, a kind man, a person who showed respect to everybody who was in front of him, a diligent worker. I got a card from Rick Harris the other day, his son, and said that Judge Harris always enjoyed being at the courthouse in Greene County when he was mistaken for the janitor because he was walking around in his sweater. I've tried to conduct my court in a similar way. I've got a 23-year record of decisions that you have available if you want to look at them. I've given you 3. One of the things I wanted to mention was that in that period of time, we're required to file these reports if it takes longer than 60 days to get a decision out. In all that period of time, I've had 5 cases in 23 years that I've had to report. 4 of those were filed the month after that, and then I had one this year that I had to take longer because of the complexity of the case. So that's one of the things that that I have a history of. Secondly, there is a concern, I think, on the part of many people that what they call black robe-itis, and that is you put on the black robe and you think you're the smartest person in the room. In some cases, that's the case. They are the smartest people in the room. In other cases, I thought that was, so anyway, I guess George Davidson didn't warm me up quite as much as he said. Here are the 3 things that I think the Supreme Court does and what I'd bring to it. One is that their primary responsibility is to decide cases. That is the primary responsibility of this court. And they need to do that. And they need to, the second thing is to administer the judicial branch from an administrative point of view. And the third thing is to monitor the lawyer's behavior. And I want to talk about those things if I could briefly. Case decisions. My first goal as a member of the Supreme Court would be to continue to render timely decisions. In the past years, there have been a number of cases that have taken a long time. I understand there may have been some conversation about that in the last day or two. All I can say is that to the extent I'm responsible for the cases that I'm assigned, I will do my best to continue my practice of deciding those quickly. I realize that there's a difference between a trial judge who makes up his or her own mind and the collegial nature of the court, but also on the other hand, I note that a lot of these decisions, even the ones that are delayed, are not subject to dissent. Maybe they're adjusted or something, but that's something that I can bring that I would work on very, very hard. The other thing is I think the court takes too many interlocutory appeals. For those people who might be listening out here or watching, if there's an interlocutory appeal is an appeal before the final case goes to trial. And I've seen that work adversely in a number of cases up in our district, not just the ones that I'm involved in, but another case where a fellow stayed in jail for 1.5 years waiting for a decision. I had one case on a medical malpractice case that I made a discretionary call in terms of the discovery, they took that up, and it took them 3 years to get a decision out on an interlocutory appeal. In the 3 years, this woman who was a plaintiff had sued a doctor for malpractice and had to wait 3 years to even get into the court because of that. That, frankly, is inexcusable. Second area, court administration. I've tried to offer constructive, confidential communication to the Supreme Court over the past 2 years on issues which I disagreed with. One, the primary one, was the layoff of the court reporters. That's the equivalent, in my opinion, of laying off the factory workers and keeping the people in the personnel office up there. The people that are doing the work, the people who need the support, are the people that are out there deciding the cases. And I recognize that things are short and cut back, but I think we made a real mistake in laying off this many court reporters. In that regard, what one person can do, I guess, is limited on the Supreme Court, and I recognize that. But what I would try to do is, one, fill the court reporter vacancies as best as possible and give priority to those hirings. Second thing I would do, I would settle the federal lawsuit against the Supreme Court for those firings. I don't know whether any of you are aware of that. It didn't get much publicity, but there's a federal lawsuit pending by the fired court reporters. I just think that has a corruptive effect on the, or corrosive, not corruptive, corrosive effect on the goodwill of our employees, and I think we need to get that settled. I realize I'd only be one person on that, and maybe there are good reasons for it, but that's one of the things I think needs to be done. The third function of the court is monitoring lawyers. I think they do an excellent job of that they reprimand lawyers, and they'll disbar them if they're doing things that are inappropriate or not to the standard that we have come to expect in Iowa. The only suggestion I might have there is I discovered 2 weeks ago that you can pass the Iowa bar exam without answering a single question on Iowa law. And the reason I found that out was we have a law clerk this year, and she's wonderful, but she had to go to a seminar last week after she'd passed the Iowa bar on Iowa law. And I just don't, that seems backward to me. But that's an area, I guess, that I would like to focus on. Last thing I want to talk about is an issue that I raised with some of you as we went around, and that is the age issue. I would say at the outset, no one has brought this up to me. I understand that some people may think I'm too old to be on the Supreme Court. It's an 8-year term. I'm 62. Mandatory retirement's at 72. If that presents a problem, I'm willing to address it. But I don't think that any common sense reading of the statute could reasonably say that a judge with 23 years of experience with an 8-year term looking ahead and is 10 years away from retirement should be barred from consideration in the court. Okay? No one has raised that with me. I was told after I decided to apply that the court administrator had written a letter to the editor of the Des Moines Register. No one's ever told me anything about that. I tracked it down. If there's a problem, I want to address it now because no one's raised it with me. When I found out that this might be a problem, I talked to a legislator and asked him to look what was happening down in Des Moines. He said there was a bill under consideration that is winding its way through the legislative process now to clarify that interpretation of the law. I asked a number of colleagues of mine to read that statute. Half of them said what this letter to the editor said was correct, that I'm not eligible. The other half said, no, all they want is somebody who can fulfill the term. So it's subject to different interpretations. I think that the interpretation being applied or being suggested in that letter to the editor is a very restrictive interpretation of that statute. That's another comments here. And one of the things I did last night when I found out that well, I knew it might be an issue, but I looked at the statute again, and basically it says you have to retire at age 72, and that 72. So I found a case that the Iowa Supreme Court decided in 2004 on the issue of age. And it's a case of in re marriage of Neff, and the site is 675 Northwest 2nd, 573. Here's what that case said. It dealt with college support. When should college support for divorced parents end? The statute said that the statute read, the applicable time frame is between the ages of 18 and 22. Here's what the court said. Given the traditional ages at which students attend college, the ages, blah, 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 students qualify so long as they are older than 17 but less than 23 to affect the legislative intent. So the statute said it ends at 22. The court said you're 22 until you're 23. I think that is directly on point in terms of how you count ages, and I'm think that I've seen, and the way you've handled other things in this proceeding, that your aim is to try and get the 9 best people, and that you have maybe taken late applications, which is fine. I think you need to see the 9 best people. I think there's some question about whether you should send up 3 groups of 3 or 1 group of 9. My understanding is you've decided to do the 1 group of 9, which again I think is very reasonable in terms of the circumstances that we're under. Likewise, I think it's not unreasonable to say that a guy who was born November 3rd with a deadline of January 1st should be barred from offering what skills he has to the Supreme Court. So, thank you.
Judge Finn, thank you very much for your comments, but I believe you're leaving this commission with some misconceptions. And I want to address 3 things. The Iowa Bar tests on Iowa law and the essay questions are specifically on Iowa law, and the course is to learn Iowa procedure, so I want you to address that. The second thing I want you to address is how, if we get a $5 or $10 million cut next year, how do we restore the court reporters without decimating the rest of the court system? And third, I guess third...
Just give me a second, I'll grab a pen here.
There's a 1969 Attorney General's opinion that addresses the age, and we are supposed to ignore that opinion too, I take it.
Well, no, you're not supposed to ignore that, and I'm sorry if I've offended you, Judge Wiggins. I am just making the argument that I think the people of Iowa would be a little surprised to hear that a 62-year-old judge with the experience that I have should be barred from consideration at the Supreme Court.
That's a legislative decision, not ours, Judge.
No, it's not. The legislative decision on that college support, that was a legislative decision, and you interpreted age 22 to mean until you turn 23. It's the same thing. I don't know about the bar exam. I haven't taken the bar exam in a long time. I do know that I got a clerk who came from Wisconsin who told me she passed the bar exam and there was no Iowa law on it, and that she had to go to this seminar you put on to teach her Iowa law. And what was the other point you wanted me to address?
How do we rehire the court reporters if we get another $10 or $15 million cut?
Well, here's what you do. First of all, you start having good relationships with the legislature. The relationship between the bar, the Supreme Court, and the legislature is not good. And I don't know whether anyone's told you that, but that is the fact. So you start with the legislature. This is getting a little testy, and I apologize because I'm not that type of guy. But I
think you are.
Well, coming from you, Justice Wiggins, that's a real compliment. And I'm sorry for that. I shouldn't have said that. I'm sure I'm making all of you uncomfortable. But there are a lot of people out there who are upset with the way things have been going here for the last 4 or 5 years. And I can tell by the heads nodding and everything that you all wish you were someplace else, and I apologize for that. I try to conduct myself in a manner that is respectful, and when I think a lot of the problem we have now is that the people who've been appointed don't listen as well as they should, and I apologize to you, Justice Wiggins, if that offended you. How are we gonna make up for it? Here's what I would do. I would start laying off the staff here. I'm sure they're valuable to you, but they're not valuable to the litigants, to the people who want to try their cases. I've got a friend whose daughter is getting divorced in Iowa City, who's had to wait a year to get a day in court. The lack of court reporters. It's a child custody case. They've been separated for over a year, waiting for time to get into court. So it does have effect on people. And I come down to this beautiful building, and I see the staff that's here, and then I go out to the rural areas, and I know that not only are there no court reporters, there are no court attendants. Obviously, you need to make some priorities, but that's where I would cut. I would cut in central administration rather than.
And how much money would that save to hire court reporters? And how many staff are left to cut?
Well, Justice Wiggins, I don't have those figures immediately available to me. I do know that we have EDMS, which is an electronic data management system that's opened up in Story County. That it's, in my opinion, not working very well, but I see that we have four technical people there in a courtroom all the time trying to get that matter going. So there are resources around. At first, I would commend you for going ahead with this program because in the long term, I think it's probably good. But if you can't feed the children, if you can't pay the electric bill, then you have to cut back on something, and that